They are saying the matter is moot. So speculative and mootness are two opposite directions. I don't think they are allowed under the rules to do that.
Mabirizi, mootness comes after the event, right?
Yes.
Yes. But if they are saying it was speculative, that no event had taken place or will take place,
That's okay.
they cannot be the same parties to say now an event purported to take place and then now that is moot. But the sum of it is that I don't think those objections should be part of the issues because they are not part of the pleadings of the parties. My opinion is that let them raise them. If they are strong on them, the court determines them, then you proceed with the conference.
Are you suggesting that if they are raised as part of the issues, you'll not be in a position to respond to them adequately?
It will embarrass my case because those matters are not in their defense.
So, Mr. Mabirizi,
yes.
I'm struggling to understand. Your contention is that the issues they have said they would like to raise, i.e., limitation,
Yes.
and mootness,
Yes.
issues you object to. Yeah? You object to the inclusion of these as issues.
Yes.
The reason you object is because these do not appear in the pleadings.
Yes. And actually, the notice of objection
Yeah.
contradicts their pleadings.
Okay, no, let's not get there first. So your contention is that issues must be inferred in the pleadings.
Absolutely.
Now, these issues that are being raised, are they matters of law or matters of fact?
Actually, they are matters of fact.
Is limitation a matter of fact?
When plainly it would be a matter of law. Plainly.
Mr. Mabirizi, you can't swallow and spit. Just is limitation a matter of
My
law
lord,
or of
limitation is both a matter of fact and a matter of law.
fact? Okay.
Because there must be some fact which happens,
Yes.
and then you do some calculation, which is also a fact.
Is it an issue of jurisdiction?
Limitation, yes,
Okay.
but
Is it a point of law? You say it's law and fact.
it is a point of land fact, because some facts have to be put in a perspective.
Is there what is the jurisprudence of court or position of law in terms of raising points of law in proceedings?
They can be raised. They can be raised.
When?
One, before scheduling conference, that's the primary point in the rules, but court may allow them to be raised at any other time.
Who can raise point of law?
A party to a case. More especially if it's against the reference, the respondent.
So when a party to a case raises a point of law, you have an opportunity to contest as the other party who is.
Yes.
So what is your problem?
My problem is that I prefer it being raised.
Is
here.
it your case? Are you telling them how to manage their case?
The reference is mine.
But they're the ones raising the point of law.
Yes, but we are here for a scheduling conference.
So you want them to raise it to your favor,
Not my
at your
favor.
convenience.
Not my convenience.
Yeah.
To the convenience of the rules. To the as
But
stated
the
by the
rules
rules.
say you can raise at any time a point of law, at any point, at any time, at scheduling, after scheduling. So why do you say you want them to raise it before? I will just ask him so that we get,
Why I'm saying they should raise it before scheduling, because when you look at their points, they actually, on the face of them, they want to defeat the entire case. On the face of them.
That's why they're in court.
That's why they're in court.
Yes.
Now, better way is let them raise them. Now, we deal with them, so that we don't get another burden of dealing with the case together with what they claim to be POs.
So in principle, Mr. Mabirizi, you're saying, I agree that you may raise a preliminary point of law, but I want you to raise it at this point in the proceedings.
Before scheduling.
You want to determine when it's raised. But we are already at scheduling now. That's why we're here today.
Yes, and we are here, and my my opinion, my side is saying those objections contradict your pleadings, but in any case, they would rather be argued now than forming part of the issues.
Before I sit down, Mr. Mabirizi,
Yes, my lord.
did the respondents comply with Rule 39? Specifically Rule 39.2?
With the 7 days, I think they did.
Yes.
Because they says 7 days before scheduling conference, I think they did.
So I'm struggling now to understand if they did raise it according to the rules, and they want it to be determined as one of the issues. How can you say, let's deal with it before we, because that is the convenience of the court as well. We determine how we progress depending on the agreements that you have made. If there's an issue raised, the court cannot tell the parties, stop, don't continue with that issue until we make a determination. Because once we deal with that subject before, that means we have to retire and make a ruling before we proceed with the scheduling conference. And that was not the purpose of today's proceedings. Today's proceeding is we proceed with the scheduling conference. So how you deal with the issues that a party raises and the court accepts, because you may raise an issue and the court says that is a non-issue. Okay.
My lord, you are the court. I'm obliged by your decision.
Yeah. So let's proceed with the scheduling, and we determine the modus of presentation afterwards. With the exception of the issues, everything else is agreed in this document.
Yes, my lords.
Yes.
Mr. Mabirizi,
Yes, my lord.
can you, in just two-word statements, just state what you think is the prejudice against your case by inclusion of these, or timing of how they are presented, so that the record is clear? What is the prejudice that your apprehension? What is your apprehension from a legal standpoint?
My lord, I've moved from that.
You have moved. So,
Yes.
so you have vacated your.
I've moved from that, and I'm obliged by your guidance.
Okay.
Yes.
Okay, let's go to paragraph 5. Evidence by all parties shall be by way of affidavits already filed and others yet to be filed. What do you mean by this?
My lord, the respondent is yet to file an affidavit. We don't have any evidence on record. My lord, our prayer is we be allowed 3 weeks to file evidence in support of the response to the reference, my lords.
So this others yet to be filed refers to the
Respondent, my lord.
respondents.
Yes, my lord.
Mr. Mabirizi, do you intend to file any other than maybe a response to?
My lord, I don't
whatever?
intend to file any other affidavit.
You're not going to file any?
No, no more. The one is enough, maybe to respond to what they will bring within a month after they have found.
A month?
Yes. After they have found and served.
In the document that we have, there are initials, like in paragraph, in the respondent's case. What is SI, number 95?
My lords, that is statutory instrument.
Yep. But how did you expect the court to know this?
Well, my lord, we do apologize. We shall do better. We can amend that.
Mr. Mabirizi, after number 7
Yes.
of your case,
My case?
is those ones following, they are not numbered. Is it deliberate or you omitted numbering? Are they part of your case?
My lord, they are not numbered because they are the contention. After stating what I plead or are the component of my case, then these ones combine
It's
all
a
the
conclusion.
above. It's a conclusion of all the above. Because when I number them, it may be like maybe there are additional points of contention. Yet actually, it's a conclusion that actually my pleading is that those processes are unlawful and that I pay for remedies. It's a concluding part of it.
So for convenience and for elegance, when you write 1 is the applicant's case, then the numbering which follows maybe should be A or
Yes.
alphabets or use Roman numbers.
Or instead of brackets.
Instead of 1 bracket. Because if you want to refer a specific paragraph, it will be problematic. But now also confirm to us that the electoral roadmap, the revised 2020-2021 electoral roadmap, is that the correct name of the document you're impugning? Is it just a roadmap?
Yes, it's just a roadmap.
It's a roadmap.
Yes.
So the document you are impugning is a roadmap.
Yes. It's a roadmap.
And that roadmap is broken down into items.
That roadmap, when you look at Annexure A, the reference has 5 pages. Now, I pointed out 5 aspects. Actually, there are seven aspects which I impugn in this court.
Yeah, but what I want to know is you're referring to, when you refer to, like in 4, items 11 to 13. What do you mean by items?
It is numbered.
So the correct terminology is items.
Yes, because he says number, activity period. So he made a table. So in this table, it is easy to refer to them by the number he numbered them. He says 11, then he names them. That's why it becomes easier for us to.
My lords, just to get back to that issue, I think for clarity purposes, I think it would be advisable for us to say activity as opposed to item. It may be quite confusing. Because when you look at the tabulated roadmap, it has the number, then the activity. So he's talking about activity 11 to, so I think we should not use item. That may be quite confusing.
But that's how he referred it in the statement of reference.
Yes.
Like items.
Okay.
We can live with it.
All right, my lords.
But make sure that also you go through it and correct the punctuations. In some places you're putting semicolons, some places you're putting full stops, in others you're not putting anything. You're opening a sentence with a semicolon instead of a colon. In item 6, you're putting a semicolon, 1-6. So make sure that you correct those punctuations.
Okay.
All right, now let's go to the scheduling. So the respondent, you want to file one or more affidavits. How many affidavits?
We're going to file one affidavit.
One affidavit in
yes.
support of the response.
Yes, my lord.
Okay, and Mr. Mabirizi, you will respond to it.
Yes.
Okay.
Within a month after they are filed.
Then 3 weeks for the respondent to file their affidavits, the affidavit in support of their case. And Mr. Mabirizi, if you intend to reply to it, you ask for 30 days.
Yes.
Okay. Thereafter, written submissions, Mr. Mabirizi, after the last pleading, it means after your response. Or you're filing at the same time,
No,
written submission and the affidavit.
No, my lord. I'll request for 45 days thereafter.
How many?
45 days.
Mr. Mabirizi, you're not being serious. This is a 2020 case. And you have a month within which to respond to an affidavit. At the same time, I think you could be filing your submission at the latest, maybe 2 weeks thereafter.
My lord, that would be ideal, but I'm a busy man and I'm alone. And I have many other cases before you and other courts, so I don't want to default and then I come here crying for extension of time.
So can we give 2 months combined, both for your response and the submissions?
I'm obliged.
2 months?
Yes.
Or 60 days?
Yes.
And Mr. Adrone?
My lord will just need a month, 30 days to respond.
30 days. And then you have a right to rejoin.
1 month is enough thereafter.
Another month. So we're talking about how many months now? 1. It goes up there.
2.
Okay. So this is the schedule of how we progress after today. The hearing will be conducted through affidavits, affidavit evidence. The respondent to file the affidavit in support of their case by 4th of December 2024. The applicant to respond to that affidavit from the respondent by 4th of January 2025 and file written submissions in support of the applicant's case by the 4th of February 2025 The respondent has up to the 4th of March 2025 to file their reply to the submissions, and any submissions in rejoinder by the applicant to be filed by 4th of April 2025. And that thereafter you will be notified of the date of submissions.
Ms. Rice.